Now, we were here on Tuesday, got notice of the 3 petitions against the Chief Justice for her removal, as was announced by the spokesperson to President John Dramani Mahama and also the Minister of State in charge of Government Communications, Felix Kwatiofosu, who signed that statement. Today, a number of things have happened. First, we had the immediate past Attorney General, Godfrey Yeboah-Dame, filed a lawsuit on behalf of his client, Vincent Ocansey, Member of Parliament for Old Tafo, against the Attorney General at the Supreme Court, challenging the procedural legality of President Mahama's actions concerning the potential removal of the Chief Justice. Vincent Asifua, acting as a concerned citizen under Article 21B of the 1992 Constitution, sought several declarations from the Supreme Court, whose original jurisdiction he is invoking, regarding the interpretation of constitutional provisions governing the removal of the Chief Justice. Getting to the details of the reliefs of Vincent Asifua, but we've just also got notice of another suit challenging the legality of the procedure of the president and the actions for the potential removal of the Chief Justice. Getting to the second suit and the details in a bit. But right even before we could get into the studio earlier today, a few minutes ago, we got a notice as well from the Chief Justice Gertrude Torkornoo herself, requesting copies of petitions submitted to President Mahama seeking her removal from office. Dennis Pabere, Madam Esquire, is with our political and legal desk, is head of research there, is joining us right now. It's good to have you. Dennis, first of all, let's start from how the day started with this. Vincent Asifua, challenging the legality of the process. What exactly are the reliefs that he's seeking? And let us understand what this suit is all about.
Well, so flowing from the happening on Tuesday, that is the presidency issuing a statement to the effect that some 3 petitions had been forwarded to the Council of State to begin a consultation process to, as it were, consider whether or not the Chief Justice should be removed. Access the petitioner's view that the Chief Justice should be removed. Mm-hmm. Now, having made that announcement, 2 days passed, we now hear that Member of Parliament for Old Tafo has now filed a suit at the Supreme Court challenging the process for the removal of the Chief Justice. Now, this comes on the back of the development on Tuesday, because the president now having forwarded these petitions to the Council of State, it means that together they are going to consider whether or not there's a prima facie case to be established, and then they'll set up a committee to go into the merit. That in itself is bringing up a lot of controversy, because now we are seeing that in the writ of summons that has been filed and on behalf of Vincent Asifua, they are questioning whether or not the procedure that has been adopted is one that should be allowed to be adopted. Is the view of the plaintiff in that matter that it is unconstitutional for the president to proceed on the route that he is on. That is to say that he ought to have notified the Chief Justice in question and also received her comments as part of the consultation process that he's on with the Council of State. That is the crux of that particular suit before the Supreme Court, or that has been filed today by the Old Tafo MP. However, we have moved past that stage where the conversation has now developed to how did that MP get to know that as part of the consultation process, the Chief Justice was not notified about the pendency of the petitions and that her response or her comments were not requested. But we'll find that answer later, because just this evening we got another statement or a letter that was addressed to the Council of State, to the President, and then the former Chief Justice, who is a member of the Council of State, and the Council of State itself, requesting to be given a copy of the said petitions. This letter I'm talking about is from her ladyship, the Chief Justice, who herself has written to these persons that I've mentioned, the officers that I've mentioned. That's the President himself, the Chairman of the Council of States, and the former Speaker of Parliament, Honorable Duajeho. Also in copy is the Honorable Justice Sophia Kufu, member of the Council of State and former Justice of the Supreme Court, and then the Council of State itself, requesting that she be given a copy of these petitions. Now she makes the argument that it is part of our laws that anytime such petitions are presented to the president and they are forwarded, the process is that the person affected should be notified and the comments of the person received to form the basis for whether or not a prima facie case should be made against the person. She's of the view that she only got to hear of this on Tuesday when the presidency issued a statement.
Right.
It's been 2 days from Tuesday to Thursday that she still not got a request, a copy of the petitions for her to also make her input. She argues, based on law, based on the same provisions that we are looking at, Article 146, that the procedure is that she ought to be given. She goes on to cite instances where petitions were made against some superior court justices, in which she was the one to determine the prima facie case element of it. She made the petitions available to affected persons and requested their comments, and that, she says, formed the basis for whatever decision she made as to whether prima facie case was established or otherwise. Now she's simply requesting that she be given the copies and also be given 7 days to offer her response and then proceed from there. Just when that was about settling, then came another suit, which was in the name of another private citizen, Ebenezer. Let me get that name right. So one Ebenezer, and his arguments substantially are the same as that of Vincent Asafua, except to say that his reliefs far exceed what Vincent is asking for. Because when you look at what Vincent is asking for by way of reliefs, it only talks about the Supreme Court making declarations that the move that the president is making is unconstitutional, is an infringement on the rights of the Chief Justice, and that any other orders that the court would deem fit. However, with this new plaintiff, Ebenezer, he goes beyond that to suggest that, or to even ask the court to restrain the president from proceeding on the route that he's proceeding on.
I see.
He also wants the court to, in fact, also withdraw the petitions.
To withdraw the petition?
Yes.
But can the president do that? Or
well,
can the
so that's what
court compel the president to do that?
That's what he's put it before the court. That will be for the court to answer that question.
Right.
But to make the case that this, even though it's the same in substance, when you look at the scope of it, this goes far beyond what Vincent is asking by way of the court making declarations in respect of the constitutionality or otherwise of the president's move, and also to the effect that it's an infringement on the rights of the Chief Justice. This person says that let's move beyond that, even make an order, a restraining order, injunct the president from proceeding on the route that he wants to. Again, also make an order withdrawing these petitions that are even before the Council of State, because his view is that the procedure is also wrong, because the Chief Justice has not been notified of the petitions, her inputs have not been made into it, and that it is unconstitutional.
I see, but then let's establish this. The president received the petition. The only time we got to know about these 3 petitions was on Tuesday when Felix Kwatiofosu issued that statement, correct?
Yes.
Now, does the law in Article 146 specifically state when the Chief Justice should be notified of the details of the said petition?
Unfortunately, you would not find timelines in the provisions of Article 146, except it prescribes that certain things should be done, which is in this case the consultation between the president and the Council of States. And then in furtherance to that, then there's the establishment of the committee. We are not told in express terms what the timelines would be, i.e. that maybe the president, when he received the petition on this day, within 7 days or 8 days or this number of days, this should be done. No, that is not provided in there. And that has not even come up for any debate as yet. But I get the point you are making, that the president and the Council of State are still in the process of the consultation. So it's only it's possible that they were still considering giving an opportunity for the Chief Justice to make an input. That is the side of it. But what we are having to deal with now is how should they proceed with it? Should they immediately have given her the opportunity to make an input, or they can wait for as long as they want and give her an opportunity later? The plaintiffs in these matters, the 2 suits, are saying that no, you have to, because for them 2 days have passed. She has not even been notified about the petition. Talk less of getting her comment. They feel that there's a threatened breach for which they want to protect.
And hold on a bit, Dennis, for me, because stay with me. Let's bring in Christian Mamhes. He's a private legal practitioner, a constitutional law expert. Is joining us right now. Counsel, good evening. Thank you for joining us. I mean, listening to the details of the case as Dennis has just put out, how does all of this strike you, especially because of what Article 146 specifically states about how this process will play out, and the demand by the Chief Justice now that, look, let me know the details of the petition against me, even though the consultation process by the Council of State is ongoing?
Yes, thank you for having me. Good evening. You remember yesterday I began a certain submission, a legal submission with you, pointing out certain gray areas. Now, considering this, you see, the Constitution is a living document, and it is strike law for any student of constitutional law that this statement is not just a statement of act, but it is an embodiment of constitutional law. And there have been several authorities espoused in the corridors of law to establish this. Now, not to bore listeners with legalese, I will just make my submissions clear and more understanding. If you look at, if we mean that the Constitution is a living organism, it basically means that we look at the Constitution wholly. So Article 146 will not be read in isolation. Article 146 would be read together with Article 19, which talks about fair trial. Now, and when you talk about fair trial, in conjunction with Article 146, a petition has been brought to the presidency. Now, the presidency is conveying that to the Council of State. So, literally speaking, the Council of State will then form a committee to deal with it. So then there will be trial of the accused person, whoever is being accused of. And that person would only be seized with matters as of then. But again, when you go to Article 19, anybody who accuses another, that another must get the opportunity to respond. Because if she does not have the opportunity to even see the petitions against her, but the petitions are then forwarded to the Council of State. Now, between the presidency and the Council of State, are they now going to determine the prima facie case? It's a question mark. She must have the opportunity to respond under the holding party rule, natural justice. She must be heard. She must see the petition for herself. She must respond. And then further procedures would follow from there. And those institutions are also enjoined under Article 23 because it is acting as an administrative body. And the Constitution enjoins them to act fairly and justiciable. Just as Article 296, that such institutions should not wield power arbitrarily. So the Constitution is looked at as a living organism in order to reflect its test and contest to the times that we are in. It cannot be taken literally.
I see, but that's why I made reference to what 146 says, and then you bring in Article 19 as well. Then again, that references the principle of fair trial. Juxtapose these two provisions in the Constitution and the process specific to this particular instance of the removal of the Chief Justice. 146 does not clearly prescribe exactly when the Chief Justice should be notified during the consultation process. It appears that this is at the discretion of the Council of State as to when the Chief Justice should be notified during the consultation process, as enshrined in Article 146, is it not?
So yes, so that what you have just said is the literal interpretation of the Constitution. And that is what I'm telling you, that a student of constitutional law moves away from that, because even at law school, you are taught that the Constitution is a living organism. And several Supreme Court authorities have come to cement this principle. And Article 146 cannot be dealt with alone in the circumstances. The same thing when the Chief Justice receives petition for her to determine the prima facie case. She needs to draw to the accused superior court judge that this petition has been made against you. You have to respond. And she does that under Article 19. And also the discretion that she has, the discretionary power that she has under Article 296 of the 1992 Constitution also comes to bear, because that also indicates that that discretionary power must not be used uncandidly. It must be fair and candid. So that if in the process, or if in the conjunctive process, all these elements of constitutional powers have not been drawn properly to conclude the procedures thereof, then we will say that you have jettisoned from constitutional procedures, and that which you are seeking to do has become arbitrary and can be challenged in the court of law as having acted unconstitutionally.
I see.
We no longer define or interpret Constitution literally. We look at the Constitution as a living organism, as a living authority.
And that's where I bring in the point that Dennis was raising earlier, that is it the case that the CJ's demand of the details of the petition against her should be made known to her right now, 2 days after the public notification of these three petitions, or the process as enshrined must then be allowed to, as it were, play out, so that maybe in the coming days, the Council of State itself, as part of its consultation process as enshrined in law, would also consult the Chief Justice and make it known to her, not necessarily as a result of her demand?
You see, she is not making a demand out of fluke. She's making a demand as of right, as of her enshrined rights under the Constitution. If you read cases like Tufo and Attorney General, it deals with cases of the Constitution as a living organism. Because if someone has accused me, petitioning against the presidency, and having occupied that high office, I only get to know of such petitions from the grapevine or from media platforms. Yet the conveyor belt procedures continues. And when it gets to Council of State, they will move on to constitute a committee for the hearing of the matter. It is only fair for her to be consulted by way of running by her what the petition says. She gets to know the constituent ingredients or elements of the Constitution. She considers it whether by herself or together with her lawyers, and then they respond. Even in court, when you bring a procedure, the other party is given ample time under the rules of procedure for you to respond. Then thereafter, other processes kick in. So what I'm basically saying is that the Constitution is not interpreted literally. The literal interpretation of the Constitution has long been departed away with. And that in modern times, the Constitution, as in the case of Tufo and Attorney General and other many Supreme Court cases, the Constitution is interpreted as a living organism. And in that situation, Article 146 is considered with other conjunctive clauses in order to ensure that justice is done.
Well,
so that is my humble
right. Lawrence, hold on a bit for me, because we also have Martin Pebo, private legal practitioner, joining us as well. Counsel, good evening. Thank you for joining us.
Yes, good evening.
It's good to have you. And just to recall a number of things that have happened today, the former Attorney General, immediate past Attorney General Godfrey Yabo Adame, filed a lawsuit on behalf of his client Vincent Tasefoa, the MP for Otafo, against the Attorney General at the Supreme Court, essentially challenging the procedural legality of President Mahama's actions concerning the potential removal of the Chief Justice. His contention is that till as of this morning, the Chief Justice had not been notified of the details of the petitions against her, 3 of them. Now, the question at the time was how he got to know whether or not the Chief Justice had not been notified of the petition. And in fact, that question has been answered, because as we speak, the Chief Justice herself, Justice Gertrude Torkornoo, has requested copies of the petition submitted to President Mahama seeking her removal, confirming what Vincent Tasefoa is actually seeking in his suit as well. The question now here is, at what point exactly is she supposed to be notified of the details of the petition? Lawyer Hesimao makes the legal point that to the extent that she has the right, at least per the natural justice, to know what exactly she's been accused of as enshrined in Article 19, 146 cannot be literally interpreted to mean that the period of notification of the Chief Justice of her petition should be at the discretion of the Council of State. I found out your thoughts about this.
Oh, you see, number one, to avoid this, generally the confusion that is emerging now. That's why in the Frank Edition case, Attorney General, right, and Bryce Akwiti, the Supreme Court strongly advocated for more rules, detailed rules to govern this process. And I see we are getting there. Now that this one is creating this problem, by the time Chief Justice Torkornoo's petitions are done with, the process will be set in place for detailed rules to be given to govern the procedure. Because what is in the Constitution is sketchy. That is what the Supreme Court itself has described the laws. 146 is small. If you look at it, on Saturday, I'll bring you the civil procedure we use in the High Court and Circuit Court. Big book. And this one, removal of Chief Justice, the same way. Let's take our time and come up with more detailed rules. So at this time, we are all giving opinions based on our understanding of the law. Now, this particular question that's arising, I don't necessarily think that the Chief Justice has to be given a copy in cases where the petition is terribly bad. So let's say a petition that is nameless. So somebody writes allegations plenty, but then doesn't write his name. Such a person, so you don't even know who is written this petition. Such a petition, the president, in consultation with the Council of State, can do the prima facie case where they say, listen, we received this petition, it has no name, no address for us to even trace the person. So straight away, I'm dismissing it. Of course, the president will give reasons, etc. And the Frank Edition Attorney General, just in case for those who want to read, is 2005, 2006 Supreme Court of Ghana law reports. Yeah, sometimes some people, even who are not lawyers, also want to take it early. So 2005-2006 Supreme Court of Ghana law reports. So that's the decision they court. So in that Frank Edition case, they said the provision for making a prima facie case is not stated in the Constitution for the Chief Justice. They've done that for only the other judges, High Court, Court of Appeal, and the rest of the Supreme Court judges. But for the Chief Justice, they didn't expressly state that when a petition is presented, there should be a prima facie case. So in the Frank Ejechum case, the Supreme Court looked at it and said, if the subordinates of the Chief Justice are entitled to get prima facie determination, then the Chief Justice too should get it. Now let's explain what is the effect and the importance of the prima facie determination. You can call it the winnowing stage, to winnow the petition, like the way we winnow maize, so that stones and those things are removed. So if we winnow and we find out that the whole petition is stones or is weevils, then we throw it away because then there is no maize for us to use. So that is to say, if you winnow and there's nothing in it, it should not go to the second stage, which will be the establishment of the 5-member panel or tribunal that will go into the case. The one that will now ask the accuser to come. Yes, stand here, give evidence. You'll be cross-examined. Were you there? You and I were not there, like the election 2012 petition. I'm using an example that Ghanaians can readily remember. Of course, the difference is that when in this case it will be done in camera, so we will not get television, the media to broadcast it. But it's the same file. Yes, examination in chief, cross-examination, etc. Even though it's supposed to be an investigation, so far we've been doing it like the way court is done. So even Samson Ladi are advocating that no, we should change it and make it more inquisitorial, where the judge will rather be in charge and do proper typical investigations like the way CID people do. But we'll leave that conversation for another time. So let's continue. So the point we are making is that when it comes to the prima facie determination, sometimes the petition can be so bad that you don't even need the respondent. Well, in this case, let me limit it to the Chief Justice. So it can be so bad that sometimes you don't need the Chief Justice to respond before the President can deal with it. That is to say, the moment the President says or sees that this petition is very bad, maybe no signature, no name, or the handwriting is so terrible that you can't even read. You go and bring all the people around, nobody can read what is being written. Those petitions that maybe the heading is clear enough, removal of Chief Justice, that one can be seen, but the rest of the petition is so bad that nobody can decipher. The President can throw it out without asking the Chief Justice to comment. And indeed, there are cases like that. When this thing happened, Georgina Wood, when she was Chief Justice, and petitions were brought for the removal of the Shrad Board, there were many, well, not many, I think about 3 or so, 4 petitions. She dismissed all except the one that Samson Ladi presented on behalf of Richard Nyama. So the other petitions, she found them not well crafted. She didn't find any proper basis, so Georgina Wood threw those petitions out without asking Lord Ramsey, then Shrad Boss, to answer. So in the same manner, against Charlotte Osei, the petition that was brought against Charlotte Osei, I understand the media reporters showed that the petitions were not signed. Yeah, there were no names. No names. And yet it was said that Akufo-Addo allowed them to rectify it. One of those, I mean, the mixing, it's a question of public record. If you Google petition against Charlotte Osei, they detect either the name or signatures weren't given. So because of that, yes, Akufo-Addo called them to come and rectify. But another president looking at it can say that no, I don't agree. Once it is not signed or once there's no name, I'll throw it out. You see? And also, like, another petition can have insult, invective, vitriol, okay? It doesn't make sense. So such petitions, the president can consult the Council of State. And listen, I want to throw out this petition. We don't even need a Chief Justice to respond. So such things can happen. So what we are saying is that to the extent that, so what we should be watching is that, and what the president cannot do is that he cannot take the petitions and then, based on only the petition, say that he has made a prima facie determination that Torkornoo should go and answer. So let's repeat. The one that I think we are all trying to safeguard in this what doesn't happen is that the president cannot reading the petitions alone decide that, well, stage 2 should be activated. That is the 5-member panel, which will be made up of 2 Supreme Court judges and 3 lay people. So the majority of that panel will be lay people who are not lawyers, they are not ministers of state, they are not MPs. So that's the design. So I think the 5-panel committee, or call it tribunal, that is the one that the president cannot go ahead and say, oh, reading this petition, I think that there's something in it. So, Council of State, let's set up the committee, even without asking Justice Torkornoo to bring her response. Of course, asking her to bring the response means that they would have sent it to her. So once the president is not doing that, as for not sending the petition at this stage, I don't think it's anything we should cry about. Of course, we should be vigilant. But so far, you cannot just conclude that because Justice Torkornoo has not been informed of the petition, then it means that it's a violation. So,
is there probably a suspicion of a possible breach of rights?
Yes. So if you have a suspicion, maybe you can ask. You see now, Chief Justice Torkornoo has written to the president for a copy. So if you had asked for it, and then he says, I won't give you, I just want to go ahead and do my determination. And of course, this cannot happen in Ghana. Ghana is changing. We are way ahead, but we are just doing for the analysis. So if, let's say, the president had written that I won't give you any copies, and without also stating that, oh, the petitions are terribly bad, so I'm throwing them out, then that's the one you can run to court. That's as requested. I heard about it. I requested for the copy, and he said he won't give me, that he's going to do his prima facie determination alone. He will not ask me to comment. When he's going to do, remember, the point I've been advancing so far is that if the petition is bad, and so the president will not take a decision that will negatively affect the Chief Justice, he can go ahead and not ask the Chief Justice to comment, and he can come out with the decision once he consults the Council of State. But if the president sees that there is something in the petition, and he's likely to rule that we should go to stage 2, and the president must necessarily ask for the response of the Chief Justice.
Very good and important derivations and details that you bring to this. And Counsel, I do appreciate your analysis of this and the questions you're asking going forward. I thank you so much. And I know that in the coming days, a lot will play out. So there's be also a lot to talk about on this. Thank you so much for your time.
You're welcome.
Martin Bebo is private legal practitioner. Joining us here on Hot Edition. A number of questions, Dennis, that he puts out there, which then brings up the further conversation of what the current legal architecture is and whether or not this provision should be a subject of amendment 146 going forward. Quick one.
Well, so this is a good exercise. We just hope that it progresses so that you add to our jurisprudence, because once upon a time, it was not very clear how the process was going to be like in respect of Article 1466, where it has to do with the removal of the Chief Justice. Because mind you, when it's with respect of the removal of the justices of the other of the superior courts, the process is clear. Refer to the Chief Justice to determine a prima facie case. The question was whether when it involved the CJ herself or himself, what should be the process? At least with the case of Frank J. Chum, we are now aware that the president would have to do the finding of the prima facie case together with the Council of State. Mm-hmm. That is the hurdle that has been crossed. Now, as to what should go into that process is what is being put on the table for the Supreme Court to decide. If they find merit in this and they want to proceed on it, I'm sure at the end of the day, the procedure will be quite clear and we'll get to know whether it is indeed a requirement that the person who is on the chopping board should be notified and also be given that opportunity to respond. But of course, these plaintiffs say that in the interest of justice, this article should be read together with Article 23 and Article 296 so that they will have a fair trial and all those things. So yes, we look forward to how this is going to pan out.
Perfect. Then it's Babel Wadam Esquire. Appreciate you for coming through, as always.
Always a pleasure, Alfred.
Thank you so much. There's going to be more of this on Ghana Tonight at 10 p.m. And Dennis is going to be with me in studio as we